with any electronic devices. And there's apologies from Stuart Dixon, Old Dennis and Jim Wells. The draft minutes are available in the meeting pack, pages 5 to 10. If you're content with their accuracy, then I'll sign them accordingly. Read. Matters arising. There's a number of work items that have been rescheduled by the Department due to a variety of reasons. The board work programme for June and July has also been updated accordingly. Correspondence, which is at page 3 of the table pack, has been received from the Department indicating that there's currently no progress to report on the introduction of technological alternatives to full body searching. This item has been removed from the meeting on the 2nd of July and is to be scheduled after the summer recess. Also correspondence in the table pack from the Office of the Lord Chief Justice confirming that he is content with the agenda for his attendance next week, subject to the understanding because he does not think the committee may lawfully inquire into a pre-devolution High Court appointment, he should be careful not to engage in such an inquiry, but is willing to discuss High Court appointments in general. Also, given the delay in introducing the Justice Bill, the legislative workshop with Daniel Greenberg will now take place on Wednesday the 3rd of September rather than in June. So the forward work programme is there for members to note unless there's any other comments around it. Item 4 then is the Legal Aid and Coroners Courts Bill. Officials are here today and if they can come to the table. Pages 23 to 109 of the meeting folder identifies the key issues for members. And we will work through the bill clause by clause, asking officials to briefly outline the purpose of the clause and the Department's response to the issues raised, and then invite questions from members before we move on to the next clause. So let me welcome Mark McGugan, Deputy Director from the Public Legal Services Division, Siobhan Broderick, Deputy Director from the Civil Justice Policy and Legislation Division, Carol Graham, the Bill Manager, and Padraig Cullen, Principal Legal Officer within the Public Legal Services Division. You're all very welcome to the meeting. As normal, this will be recorded by Hansard and will be published in due course. So I'm going to hand over to yourselves to outline briefly Clause 1. So I'm not sure who's taking the lead.
Thank you, Chairman. I will take the lead for quite a lot of this.
Okay.
Just as an overall summary, the purpose of the bill is to dissolve the Commission and to create new arrangements for the delivery of legal aid within Northern Ireland, within the Department of Justice. Clause 1 will dissolve the Commission and transfer its functions and staff to the Department. On transfer, is intended that an executive agency will be created within the Department to administer the delivery of legal aid services. Subsection 5 refers to Schedule 1 to the bill, which makes provision for the transfer of assets, liabilities and staff from the Commission to the Department. I'm not sure, I mean, the section is pretty straightforward. I'm not sure, Chairman, whether there were too many comments. The Legal Services Commission welcomed this clause. The Bar Council welcomed any improvements to ensure transparency, predictability and accountability. And we believe that the new arrangements will facilitate that.
Okay. Any members, any questions on Clause 1? Okay, Clause 2. Designation of Director of Legal Aid Casework.
Clause 2 makes provision for the appointment of a Director of Legal Aid Casework. And the purpose behind the creation of this statutory position is to help ensure there will be no ministerial involvement in individual funding decisions on civil legal services. The Minister will be required to designate an individual as the Director, and the Director's function will be to take decisions on the grant of funding for civil legal services in individual cases. Subsection 2 requires the Director to carry out the functions of the office on behalf of the Crown. Subsection 3 provides that the service as the Director is service in the Northern Ireland Civil Service. and subsection 4 requires the Department to provide civil servants or other persons to give appropriate assistance to the Director. I think in relation to this clause, Chairman, we had a number of comments from the Law Society and the Association of Personal Injury Lawyers and the Bar Council. The Law Society suggested that it should be an externally recruited figure, preferably somebody with experience in civil justice matters. The Association of Personnel Injury Lawyers were concerned to ensure that the Director of Legal Aid Casework was legally trained, arguing that that would reduce the number of appeals going forward. Bar Council outlined concerns that there was no requirement for the Director to be legally trained or qualified, and that this may lead to more challenges through the process. In response to that, I think the Department would say, first of all, that the Director will take each of his decisions individually and independently of any interference. And I think the Director will have recourse to independent legal advice as and when required. There are an awful lot of cases which go through requests for civil legal aid which are relatively straightforward, and the majority of them will go through on the first request or after subsequent information has been required. And it's only in more difficult circumstances is there a need for a review process. In taking his decisions, the Director of Legal Aid Casework will have access as required to legal advice in order to support that process. And we don't. The Director will require a number of skills in terms of running a large agency with a considerable budget like this, and the legal support is just one of those.
Members, Mr. McCartney.
In relation to where the Law Society said that somebody external to the department should be recruited, is that a possibility? Could that happen, or do you feel it has to be within the?
Well, it depends on the nature of what the appointment would be. The person who's employed in an agency would normally be a civil servant. So if you're appointing somebody from outside the department or outside the civil service, effectively on appointment they would become a civil servant. It could be the case that they could be recruited from outside the department. For example, it's a senior civil service post, and currently all of those posts at those grades are being recruited externally. There's an external competition running now, and ultimately you could get an external person going into the post. And I think, the Law Society at one stage certainly had, as I understand it, and it's going back a number of years now, had an individual who had previously been a civil servant running the legal aid department for them at that particular time.
No, but the bill states that the department must designate a civil servant in the department.
Well,
So I'm not saying that shouldn't be the case, but I'm saying does it have to be the case? In other words, if someone outside the department sees this advertised, we're legislating that they couldn't be appointed?
Not necessarily. The person, if they were recruited, would be recruited to the department first, and then the Minister would designate that individual as the Director of Legal Aid Casework. So, you could run an external competition. Somebody would be recruited into it wouldn't be a public appointment as such, but somebody would be recruited into the department and then could be designated as the Director of Legal Aid Casework.
I don't think it's clear reading it. Like when you read that, it says the department designated a civil servant in the department. If you're reading that and seeing it as an advertisement, you might think if I'm not in the department, I couldn't apply for that.
Well, if it went to an external recruitment process to fill the post, I think that the recruitment process would make clear that your appointment would be into the department in the first, and following that, you would then be designated as as the Director of Legal Aid Casework. So, I mean, administratively, you would address that issue.
Okay.
So would there be a competition, both internal and external then?
Well, we don't have any plans to do that at this point in time. And I'm not sure that we've looked precisely to see what the mechanism is for transfer of the existing responsibilities. There's an individual who's currently the Chief Executive of the Legal Services Commission, and we would have to look at what happens in relation to that individual, the potential for retaining the expertise over a transition period, and then looking at how you fill the post again in the future.
And taking that into account about the current transition, but going into the future, would there be competitions for this post, or would it just be the Minister will designate who he wants, or will there always be a competitive process for someone to get this particular job?
Well, I would say that there wouldn't necessarily always be a competitive process. There are a number of ways in which people get moved around in the senior civil service. One is you could have a direct competition into it. You could have a competition within the existing grades of staff across the NIC, across the SCS cadre, across all of the departments. Or you could be looking at a managed move within the department or more generally across the SCS.
Mr. Elliott?
Thank you, Chair. And again, it's on the very same topic. I'm not comfortable with the actual wording of the way it's written, as Mr. McCartney has highlighted. Department must designate a civil servant in the department as a director. I know you have indicated, Mark, that if there was an outside recruitment or a wider recruitment, that person would be recruited into the department and then appointed. However, should it not be the opposite way round, that the person is recruited to the position and then they become a civil servant? To me, that's a better way. I don't want to discard the opportunity for a civil servant to become the director, but I also don't want to discard the opportunity for someone from the outside the civil service to become, or certainly outside the department, to become.
Going back to what I was saying in response to Mr. McCartney, Mr. Elliott, there are a number of ways in which this type of post can be filled, and sometimes it will be done through direct recruitment directly into a post. Now, when you do that, ordinarily you become a civil servant first and the post holder second, because you then bring with you rights in terms of, which are wider than just that post holder, in terms of your own tenure and so on. In most cases, you are recruited into the SCS and then find your way into a particular post. There have been occasions in the past, and probably continuing on, where people are directly recruited into a post, but it's usually through the process of becoming a civil servant, but in response to that particular post. They then retain the right to be able to move to other posts.
But you say that is a normal way of doing it, but is there anything to stop an open recruitment process that actually could allow people who are not civil servants, but also people who are civil servants, to apply for that post? Is there a method of doing that?
Yes, there is.
Okay.
There is. Any open competition. So if this post was identified as something where you wanted to have an open competition, that competition is not just open to people outside the civil service, but also people internally within the civil service as well, so that they're not excluded from it. So any competition would be open to both internal candidates and external candidates if it was an external recruitment process specifically for this post.
Okay. Thank you, Chair.
Okay. Clause 3.
Right. Clause 3 is exercise of functions by the Director, and this clause includes a number of safeguards to guarantee and protect the independence of the Director and his decisions on the grant of civil legal aid in individual cases. Subsection 1 requires the Director to comply with directions given by the Department and to have regard to guidance issued by the Department. Subsection 2A provides that the department must not give a direction or guidance about the granting of civil legal aid in individual cases. 2B places a duty on the department to ensure the director acts independently of the department when applying guidance or direction or guidance. Subsection 3 requires the department to publish any directions or guidance, and subsection 4 provides for directions and guidance under the section to be revised or withdrawn from time to time. In an overview, the department can issue guidance and direction about carrying out the director's functions, but not in respect of individual cases. Indeed, the department is under an obligation to ensure that the director acts independently when applying a direction or guidance in relation to an individual case. I think, to go further, that when the director refuses an application for funding or further funding, there's provision elsewhere in the bill for an independent appeal panel to hear appeals against those decisions. Looking at the comments from the consultation, the Law Society stated that the department had not taken on board the concerns of the Joint Committee on Human Rights about the designation of a departmental official as the Director of Legal Aid casework. The committee felt that adherence of such an official in the Civil Service Code, pledging loyalty to the Minister of State, effectively trumped the practical arrangements of the guidance. There were a number of other issues around the concerns raised by the Joint Committee on Human Rights and the need to ensure compatibility with Article 6. And I think the Law Centre proposed a number of amendments. Chair, I don't propose to go through all of those because they'll be in your briefing. However, what I would say is that when we were putting together the safeguarding regime over individual decisions, when we were developing the new arrangements, we were indeed very alert to the issues which had been raised by the Joint Committee on Human Rights. And indeed, the Joint Committee on Human Rights was concerned about the independence of the Director of Legal Aid casework in an environment where there was not access to an independent appeals mechanism. We addressed that in Northern Ireland by creating or making provision in the bill for an independent appeals mechanism. So the final arbiter, ultimately, if the Director of Legal Aid casework refuses an application for funding or refuses an application for further funding, is to this independent appeals panel, which we will talk about later on. So I think that we have addressed, in the provisions that we have addressed the concerns which some individuals have highlighted, which came from the Joint Committee on Human Rights in Westminster.
Mr. McPartner.
Thank you, Chair. In relation to the specifics of the Law Centre's amendments, is there any particular reason why you don't think that would strengthen the bill?
I'm just checking to see whether I have.
So page 8 of Hansard, if you had the Hansard of the... And the reason why I sort of asked the question is that, and I know you were at the role in the Long Gallery, I mean, a number of people raised issues or concerns around independence and conflict of interest. And to me, these two proposals would seem to, if you like, strengthen and mitigate against those particular concerns.
Have you found them, Mark?
Yeah, I've got them here. The Law Centre have suggested the addition in
In relation to clause
3.1,
321, it's comply with the directions given by the department by carrying out the director's functions, save where this compromises the director's independence. So that's their addition there. I'm just wondering if you have any particular reason why you don't find that acceptable.
Well, I don't think it's necessary, because what we're protecting here is decisions on individual cases, and clause 3.2a is the department mustn't give direction or guidance about the carrying out of those functions in relation to an individual case, and also in 3.2b to ensure the department must ensure the director acts independently while doing that. So I'm not actually sure what is added by the additional element that has been suggested.
Except that it becomes very explicit. It becomes very explicit about independence, and if, in a sense, if you don't feel they're necessary, then putting them in shouldn't be any burden.
In terms of how we looked at this, we looked at it in the broader scheme, and I think there are some comments which came from wider consideration in Europe about what a legal aid scheme should look like and its dependence. And we looked at in terms of how the director would apply his function within the broader legislative framework. And the director would consider applications, and I think one of the concerns was in terms of the director's ability to challenge or applications for funding to challenge decisions of government. I mean, in all of the activities that he undertakes, the director will be bound by the specific requirements of each of the schemes involved, which set out the criteria for taking those decisions, and will do that independently of the department. Yeah. The other thing is, the other aspect to this is to, in terms of drafting, and we've been through the legislative draftsman with the detail of these bills that was coming up. I'm not sure that there would be any unintended consequences if we added something that we can't identify at this point in time, if we added additional wording into the carefully crafted wording from the legislative draftsman.
Okay, but it's just as a sort of proposition, if this became, and I don't expect you to answer it here now, but if that became an amendment, it's not something which you would say, look, if you do this, it's going to result in something that's negative to what we're trying to achieve.
I can't see that impact at this particular point in time, but I would like to take it away and look at it.
And it's the same with the proposition in relation to clause 3.2. Reading it and from the presentation in the long gallery, it seems to add strength to what you're trying to achieve, particularly when issues around independence and conflict of interest are raised. So again, I'll just ask, maybe not today, but maybe to come back with a considered view of that. If they were tabled as amendments, what would they were?
Yeah. Again, I don't think that there's anything there particularly. I'm not sure the extent to which it actually provides any strength to the clause as it stands and the overall scheme as it stands. And I've tried to tend to look at this overall package of measures which each of the clauses contribute to in their own way, and I'm pulling it together.
Okay, Chair, thank you.
Chair, I wonder if I might just intervene with an additional comment, if it's of assistance. In relation to the Dallow letter, which is before you, it addresses about the potential impact of directions and guidance, and if I may refer you to the 5th page of this note to you, and we say out there that, respectfully, that it may be important that to address the issue about the potential impact. This is on page 5 of the Dallow letter.
and whether some misunderstanding may perhaps have arisen about the potential impact of directions and guidance. And as we note there, that it must be emphasised that any direction or guidance issued by the department cannot override relevant legislation, whether that's primary or secondary legislation. The guidance and directions sit under the umbrella of the formal legislation, primary, and then the details in the various secondary legislation. If that's of assistance, and you'll see that that letter then goes on to give two examples of one of directions and one of a direction and the other of guidance which has been issued to date, if it's of assistance to the committee.
But the comment you make in relation to these particular amendments, are you saying they apply here?
Yes, well, just in terms of what, there's clear understanding of what directions or guidance can do. Directions or guidance cannot override the legislation, whether it's primary or secondary. And just respectfully, that within the wealth of material that is before the committee, respectfully that point of detail, respectfully, is clearly articulated by us.
Clause 4.
Clause 4 is the delegation of the functions of the director. Subsection 1 allows the director to delegate his functions. This enables the director to delegate, for example, decision-making in relation to the merits of a legal aid application, the application of any relevant merits tests for a particular area of work in relation to legal aid application, and the ongoing monitoring of decisions. Subsection 2 provides, under Clause 3, the department may give directions about the delegation of the director's functions. The department will be able to require the director to delegate or not to delegate particular functions, to give directions about persons to whom the director may or may not delegate those functions. Subsection 3 ensures that the function of the director may be delegated entirely or subject to limitations or conditions. And for example, decision-making in relation to the merits and financial eligibility may be delegated to a provider, whether solicitors in private practice or the voluntary not-for-profit sector, in relation to particular matters or subject to financial limits as to the amount of work which can be carried out in a case before it must be referred to the director for a decision on further legal aid funding. Sections 4 to 8 make provision about the effect of delegation in the earlier subsections. Subsection 4 gives the power to limit the duration of a delegation and to revoke that. And there are a number of other protections then as you go through it. I think the Association of Personnel Injury Lawyers suggests that anyone considering an application for legal aid, whether it's a director or someone whose functions delegated to them, should be legally qualified and have legal knowledge, experience or training. The Bar Council also talked about the existing system of panels and that's in relation to appeals. They appear to be. I mean, in effect, Chairman, this clause is about the ability of the Director of Legal Aid Casework to delegate decisions to his staff, but also outside the organisation, for example, to a solicitor in a particular scheme to do a certain amount of work. For example, I think under the Green Form scheme, they'll be able to do a certain amount of work before having to come to the Director of Legal Aid Casework for approval for that, and that's what this facilitates.
Chair, just quickly, does the director at present have authority to delegate powers?
I believe that he does, yes. I mean, it's virtually...
Yes, fairly similar to what's
yes.
there. Okay.
It's about easing, I mean, part of this is about easing the process and allowing and facilitating decisions to be taken at the right level and in order to
And
make it work.
at present, could that be delegated to an outside panel or to an outside group of lawyers?
Yes, again, under the current legislative framework, under relevant secondary legislation, yes, it is solicitors deal with initial funding, what's called legal advice and assistance, or reference to a green form scheme. Solicitors apply the financial eligibility test for that and can provide work up to a specified limit. When they reach that limit, they then can apply to the Legal Services Commission for an extension of funding. But in the first instance, the solicitor makes the decision making. And the second form of funding under the current scheme of what's called ABWAR, or assistance by way of representation. Again, the solicitor applies the financial eligibility test for that, and then can apply to the Commission for authority to fund the work to go to court for certain types of cases. So it will be reproducing that form of arrangement for the lower level of cases. For cases in the County Court and the High Court, they must apply to the Commission outright for funding.
All right, thank you, Chair.
Other members? Clause 5.
Clause 5 is the annual report of the Director and the requirement of the production of an annual report by the Director of Legal Aid Casework on how he carried out the functions of his office during the financial year, and then the other provisions are about sending it to the department and it being led. I think that this is broadly welcomed, although the Law Centre raised an issue about the late publication of the existing experience with the Legal Services Commission and the late publication of their annual report and accounts. I think it's fair to say that the situation has improved significantly within the Commission, in that generally the reports are now published in line with the required framework, and there are, as I think you pointed out, Chairman, there are other requirements as to the publication of annual reports and accounts. Now, there's a question mark over whether this report would form part of the annual report and accounts, or whether it would form a separate report, but we would envisage that it would be published in line with the timing of those.
Okay. No members? Clause 6.
Clause 6 introduces Schedule 2, which contains a large number of amendments. The main statutory provisions governing legal aid are the Legal Aid Advice and Assistance Northern Ireland Order 1981, the 81 Order, and Access to Justice Northern Ireland Order 2003 Order. The 2003 Order will ultimately replace the 81 Order, but large parts of it remained uncommenced, and that's been a complicating factor in bringing forward this bill. In order to support the Legal Aid Reform Programme, the provisions in Articles 10 to 14 and 17 to 20 of the 2003 Order regarding civil legal services will be commenced at the same time as the Commission is dissolved. And pending commencement of provisions 21 to 31 of the 2003 Order regarding criminal defence services, representation in criminal cases will continue to be provided under Part 3 of the 81 Order. So, as an interim measure, the bill will also amend Part 3 of the 81 Order to replicate some of the provisions in the 2003 Order regarding the assignment of solicitors and counsel, provide for a registration scheme, and place restriction on the disclosure of information in relation to criminal legal aid. I'm not sure, Chairman, whether you want to go into the detail of that now, or whether you pick it up during the discussion of the schedule itself.
Yeah, if you're going to cover it in the schedule, we can do it in the schedule.
The only comment was from the Bar Council, who said that they'd sought legal advice in relation to it, and they would revert to us or revert to you in due course, and we would welcome sight of that as well.
It's fine. Well, I have no questions on Clause 6. Do you want to touch on Clause 7? Or had you planned to? No, the next one's scheduled to.
Do you want me to deal, I was going to ask if we could deal with clause 7 and 8 together, Chair, because
Yes.
they're interlinked.
Yeah, that'd be great.
They both deal with the Coroner's Court, as you can see. Clause 7 makes the Lord Chief Justice President of the Coroner's Courts by amending Section 12(1)(d) of the Justice Northern Ireland Act 2002. This section lists the courts of which the Lord Chief Justice is already President and is amended by adding the phrase Coroner's Courts to the list. The inclusion of this amendment in the bill makes it subject to cross-community support under Section 84 of the Justice Northern Ireland Act 2002. Clause 8 requires the Lord Chief Justice to appoint one of the coroners to be the presiding coroner, who will have responsibility for the coroner's courts and the other coroners. It also provides that the presiding coroner will hold office in accordance with the terms of his or her appointment. If the office becomes vacant, the Lord Chief Justice may then appoint an acting presiding coroner pending a new appointment. These provisions are consistent with the existing arrangements for the appointment of presiding county court judge and presiding district judge magistrates courts. And the clause 8, 4 and 3 provide for some small consequential amendments arising. There were 2 comments that we received in respect of these from the Human Rights Commission. They were asking whether the provisions would assist in the delay in the coroner's courts. The Policing Board asked a similar question and asked for more details in respect of the presiding coroner. The changes are intended to assist in the better administration and case management of inquests, including legacy inquests. The role of the presiding coroner will be to facilitate the coordination and management of cases in the inquest system, including legacy cases.
Any questions, members? No? Okay, thank you, Siobhan. Schedule 2.
10 and 11 are the supplementary incidental provisions and the repeals. Are you happy enough with those? And we'll just go on to the schedules.
Yeah. No issues.
Schedule 1 is straightforward, and it's about transferring the staff of the Legal Services Commission to the new executive agency in the Department of Justice. The bill provides for persons who, immediately before the dissolution date, are employed by the Commission to be transferred on that date to the employment of the Northern Ireland Civil Services. The transfer of undertaking Protection of Employment Regulations 2006 will apply, and all of the staff will move on to the NICS terms and conditions. I think it's fairly straightforward. The Information Commissioner identified that he would be in touch regarding the transfer of records from the Commission to the Department, and we welcome that engagement.
That's everything on Schedule 2, yeah?
And Schedule 1.
Sorry, Schedule 1, okay.
Schedule 1.
I'm going to cover Schedule 2.
Schedule 2, this contains a large number of amendments, and I've introduced that already when talking about the clause 6. If we run through them. The first substantive of issue really is the assignment of solicitors and counsel, and the bill gives the Department the power to make rules that must grant a legally aided person the right to select any representative, that solicitor or counsel to act on his or her behalf, provided the representative has not been prohibited from being so assigned by either the Law Society or the Bar Council. There's a rule-making power, and the Department could, amongst other things, prescribe the circumstances where the right to select a representative did not apply, or restrict the right to select a representative in place of a representative previously selected. Effectively, there's a fundamental right to select your own representatives, but there are occasions when people want to change the representative, and the rules would set out where it's reasonable to change. For example, if there's a fundamental breakdown in the relationship between the individual and their legal representative. I'm not sure if there were any particular comments raised on that aspect.
The examiner of statutory rules has raised an issue with the committee about the affirmative resolution initiating a lot of this, but then it's negative resolution subsequently, and is suggesting that it really should be affirmative on all occasions. What's the department's view as to why it should be negative resolution?
I'll defer to Patrick on this, but in order to set the context, my understanding is that where there are issues like this which are set down in rules and regulations, it is standard practice to allow the Assembly to have the opportunity to look at the first set and look at the detail of what's included in the rules and regulations and to consider carefully what their intent and their practice is. Subsequently, there are minor changes and modifications made to those, and it's normal practice for them to be taken forward by negative resolution because they're effectively reasonably minor changes to an existing framework. Patrick, do you want to add anything? Yes, go ahead.
Yes, Chair. If the committee have available to you the supplementary note which the department submitted upon receipt of the examiner of statutory rules advice, and we record there that, as Mark has referred to, our understanding that normally statutory rules are subject to the negative resolution procedure. We also make reference to the fact that in terms of the current drafting of these clauses, that it reflects a previous approach in relation to the Justice Act Northern Ireland 2011, which made two reforms to financial eligibility in respect of criminal legal aid, where it's provided that the first set of rules will be subject to the draft affirmative procedure, but subsequent rules will be subject to the negative procedure, as the clause here is currently drafted. But we respectfully, of course, note the views expressed by the examiner of statutory rules, and most respectfully, I mean, if the Justice Committee, together with the Assembly authorities, wish to provide that all the rules should be subject to the draft affirmative procedure, respectfully, the department wouldn't wish to argue against that.
Okay. Okay. Clause 12.
Registered. Continuing with Schedule 2, register of solicitors in council eligible to be assigned. And the bill gives the department the power to make rules in relation to representatives who are eligible to be included in the proposed registration scheme. It will be subject to a full public consultation and affirmative resolution before the Assembly prior to its implementation. The scheme is only included in this bill as the department is not in a position to commence the criminal defence services provisions in the 2003 order, and it's necessary for the provisions in relation to the criminal elements of the registration scheme to be reenacted in Part 3. The rules could prescribe the code of practice setting out the conditions that must be met by representatives to qualify for registration, require registered representatives to comply with the code and enable compliance with the code to be monitored and introduce sanctions if they're not in compliance with the code. I think this is something which has been that was in the 2003 order and not commenced, and the Public Accounts Committee, in looking at the Legal Services Commission's performance, was critical of the delay in bringing this forward. We have engaged with the Law Society in terms of developing a code, and we plan to engage also with the Bar Council. I think the Law Society were concerned that the 2003 order had an element in it which required the Department to consult the Lord Chief Justice, the Law Society and the General Council of the Bar of Northern Ireland and undertake such other consultation as appears to him to be appropriate. I think there's, in terms of this particular provision, there are other provisions in the 1981 order which requires the Department to consult with a number of statutory consultees, including the Lord Chief Justice and the Attorney General. When bringing forward the rules under this rulemaking power in compliance with their obligations, the Department will always consult with both the Law Society and the Bar Council. In other words, it wasn't necessary in this section to prescribe the statutory consultees as they already covered elsewhere in the 81 order. And I think we have established the practice that we would consult with the Bar and the Law Society on these issues as a matter of good practice.
Okay.
Okay. Restriction on the disclosure of information. The bill includes provision to prevent the disclosure of information in connection with a person seeking criminal legal aid, except with his or her consent is permitted under the prescribed rules made by the Department. And it brings the schemes for civil and criminal legal aid into the same practice. Effectively, this means that if information is being disclosed by an applicant in support of their legal aid application, it will not be disclosed more generally. But that does not preclude the publication of information in relation to the amount of funding paid to any person as part of that process. I don't know if we had any concerns about that. Schedule 2, Part 2, then, is funding of civil legal services by the Department. And this section is largely about replacing the arrangements for the Commission with the new agency of the Department. The Law Society outlined that at paragraph 611 of Schedule 2 of the draft bill...
Sorry for interrupting, but as far as I'm aware, there's no more issues that we have with Schedule 2. Unless there's other members who had something further at Schedule 2, just to save a bit of time. So we can... You've addressed the ones that we had taken note of.
Appeals panels? Are you happy enough with that? There were some issues raised about the composition of appeals panels and so on, and maybe I'll take a minute just to address that.
Yeah, so, sorry, you're right around the appeals mechanism.
Yes.
Demonstrating the independence of it.
Yes.
Okay.
There is an existing appeals mechanism which is currently a panel of barristers and solicitors which have been recommended, nominated by the professional body, who hear appeals against the decisions to refuse the grant of legal aid or to refuse further funding. In the bill, we've made provision for enhancing the existing arrangements by the appointment through, in line with the public appointments process, of a new set of appeal panels to hear those appeals. When we consulted originally in relation to this, we suggested that the appeals could be heard by an individual sitting alone. In response to the consultation, which came back and said you'd get a better class of outcome if it was a panel of members, we have agreed to have a panel of 3 members. We also were keen to ensure that there was a range of experience in the appeals panels and open it up to people who would have experience in the relevant areas, for example, in relation to social care and so on for family matters. There was a very strong argument came back to suggest that there was a need to have lawyers on the appeals panel, and indeed that the presiding officer of an appeals panel should be a lawyer, and we will be bringing forward regulations to facilitate that. So there will be the appeals against the refusal of civil legal aid or refusal of additional funding would be heard by a 3-person appeals panel. The presiding officer of that appeals panel will be a practising lawyer, and we would hope to have some wider experience on the panel, but we would also expect to have a number of lawyers involved in that.
Mr. Elliott?
Just querying that, is the appeals panel decision final?
The appeals panel's decision is final. It is subject to oversight by the High Court through the judicial review process. So a decision by the appeals panel could be judicially reviewed, but it does not go back to the Director of Legal Aid Casework to ratify the decision. That their decision is final once it's taken.
Just thinking, Chair, of the Department of Agricultural appeals process, whereby the appeals process can actually find in favour of the applicant, but then the department can overturn it. But it's not like...
No, it's not like that. And I think, to be fair, we were developing our proposals. We watched very carefully and looked very carefully at what was happening in England and Wales. The comments which were being made by the Joint Committee on Human Rights at Westminster and the concerns that they had about the independence of the overall process. And in our view, the independent appeals panel and the construction that we've got now will underpin that independence of decision making going forward.
Chair, just for clarification, can I ask Mark, when you say it's 3 of a panel for the independent appeals panel, Mark, is it 3 Pacific or is it 3 persons chosen in Pacific with specific sort of expertise in different areas chosen, or is the Pacific 3 panel that sits basically forever and a day until they're replaced, or can you choose so many from a number of areas? That's all I'm trying
We're
to
working up in detail the proposals, and we'll be bringing them to the committee as part of the regulations. The intention is to have a panel of people, effectively 2 panels of people. 1 panel of people which would be the chairs of the presiding officers of individual appeals panel, and then another panel from which you can draw members. Yeah. Now, you would hope that you would, if you had a set of appeals coming forward for a specific class of cases, you would look and try and make sure you've got the right experience in that appeals panel going forward. As part of this whole process, there aren't a significant number of appeals coming forward now. I mean, 70% or something like that of initial applications are awarded on the first or second pass. Our proposals, we are planning to improve the administrative processes so that when an application is refused, the applicant will get detailed reasons for the refusal. If that amounts to a deficiency in their application, then because they've got detailed reasons, they will be able to address those deficiencies when they send it in. If it's because it sits outside the remit of the scheme that they've applied, then that will be clear to them. So through that process, we would hope to reduce the number of cases which get refused and get to the appeal stage, and therefore the appeals panel would be hearing a much smaller number of appeals.
So basically, what you're saying is possibly 2 appeals panels.
Well, it could be several. It could be several appeals panels. Yes.
So there would be a number of people appointed who could sit in those appeals panels.
Yes, and drawn off them.
Okay. Thank you.
Okay. Thanks.
The only issue is the Attorney General's amendment, if you want me to address, or...
Well, I hadn't really planned to ask yourselves about it, to be honest.
Okay.
Thank you. See who do you want? He's not that here.
Should be.
Members, just on the issue of the affirmative resolution issue, have members a particularly strong view or not around that matter? The Assembly Examiner for Statutory Rules has obviously been in correspondence with the committee, saying that he's of the view that it's significant, the powers, and believes it should be by way of affirmative resolution for the subsequent stages. So we can't hear from the Assembly Examiner for Statutory Rules if members thought that would be helpful.
Chair, it might be useful. I'm not entirely sure of how significant it is, but obviously the Examiner of Statutory Rules can enlighten us. But I suppose I always go on the side of caution. If in doubt, then go for affirmative resolution. That's my theory, so it might be useful to hear.
Okay. Well, we'll go ahead and ask the Assembly Examiner to come to the committee and ask him to speak to it. Okay, the next item then is with the Attorney General, who is with us. And it's on pages 111 to 124 of the meeting folder. Also, there's been some correspondence from the Health Minister in respect of the proposed amendment. The Health Minister has indicated that, in principle, he has no objection to the Attorney General having the power to access the information necessary to allow him to discharge his functions under the relevant powers. He has concerns if the proposed amendment goes wider than that. In his view, the wording of the amendment seems to suggest a power to obtain information relating to any death occurring within the health and social care system, even where the Attorney General has no reason to believe an inquest would be advisable, and therefore it would be important to have more policy clarity as to the precise intent of the provision and how it would be used in practice. He also notes concerns from others in respect of using this bill to make the proposed amendment. So, can I welcome the Attorney General, Mr John Larkin, QC, to the meeting, and as usual it will be recorded by Hansard, and obviously you've picked up on some of the Health Minister's issues which I think other members may have in respect of some other context as well. So at this stage I'll hand over to yourself.
Well, I'm very grateful, Chairman. Once again, it's a pleasure to be before the committee. Can I draw attention to the letter from Ms McCandian to the committee clerk dated the 30th of April. That sets out different text, different statutory text from that which was previously circulated to the committee, and this text makes it clear that it's confined to deaths occurring within a health and social care context. The text seems to me to be largely straightforward. I note the concerns that you've helpfully reproduced from the Health Minister. It doesn't strike me for two reasons. This is going to give rise to a burden on the health service. The context, the policy context, I think ought to be tolerably clear. It's come to my attention, both directly from my experience, but also from the media, that there is a concern about deaths occurring in a hospital context in particular, where there has not been reference to the coroner, where there appears to be a gap in potential investigation for accountability. This is designed to close that gap. Textually, I don't think this is capable of overreach. Its context seems to me tolerably clear. And the second, more pragmatic reason is simply that even if I wished, which I don't, I simply don't have the human resources available to me to put a burden, as it were, on the health service, which of course in no way any part of my function to do. But I think there is a concern that deaths can occur in a hospital context, and it is largely the decision of doctors at present as to whether or not those matters are referred onwards to the coroner. This amendment will, I think, enable that gap to be plugged. It'll be possible to obtain information, for example, about those serious adverse incidents which haven't been referred, for example, to the coroner, and indeed those deaths which may be regarded as suspicious or as giving rise to concern, which for whatever reason may not be classed as serious adverse incidents. Because one of the concerns would be that if one confined it ab initio only to cases of serious adverse incident, that one might find some elasticity in the definition of serious adverse incident.
Okay.
So with that briefest of brief outlines, Chairman, I'm happy, of course, to respond to the questions of yourself and the committee.
Okay, and some of the evidence that we heard, and I suspect others, believe that this would be a very useful amendment to be applicable right across the board. And so let me cut to the chase. There would be those who would want this power to be applicable for investigations into the past, particularly to use against the state. In any way, could this amendment open up the floodgates, so to speak, from that particular agenda?
No, it's textually confined to healthcare or social care, so it could not do that. Now, I understand the argument that this should be a broader power, and indeed the draft that was submitted earlier, although it was always clear that the policy context, at least as far as I was concerned, was health or social care, would have lent itself potentially to broader application. This text does not lend itself to broader application. Now, there is a huge debate, as we know. I've contributed to myself as to how we deal with our troubled past. I would suggest that this is designed to address an issue which is very much alive here and now, and that it would probably be not a good idea at this stage to give a general power which might be capable of a legacy application other than in the context of a more global approach to those difficult issues.
Okay.
But to confirm, Chairman, this text can't be used that way.
Thank you. Any other members have questions? Mr. Elliott?
Chair, just very welcome and thanks for the information. Just a query that was raised again by the Minister of Health is using the vehicle of this bill to change the legislation. What is the reason for that?
Well, the clues in the title, the Legal Aid and Coroner's Bill, this deals with an aspect of coronial procedure, so it strikes me as falling very squarely within the context of this bill. The issue which the amendment seeks to address is, I dare say, a reasonably urgent issue. We're all familiar with the media reports about deaths occurring, but non-reference to coroners. This is a very timely opportunity, I think, to address that important issue.
Do you think that's an easier way than actually amending the Coroners Act itself?
Well, this will do that. This will introduce a new Section 14A.
Yeah. But just directly amending it without going through another bill?
No, this introduces a new Section 14A.
Yeah, I know it does, but could you amend the Act as it was without using this bill?
You would need a separate bill for that.
You need a separate bill. Okay, thank you, Chair.
Okay. Any other members?
Just one question. In relation to using this power, how would it come to your attention to use this?
Well, that's very good question. I think what I would do is I would explore ways of efficiently drawing out the information. But I'm conscious that the information that tends to come to me is pretty largely Belfast concentrated. But we would probably engage in a number of pilot exercises with respect to the hospitals outside Belfast and seek information about the serious incidents that hadn't been referred to the coroner, for example, from Altnagelvin, to take one place of obvious interest to yourself, Mr. McCartney, and see then if in the cases that had not been referred that were classed by medical personnel as serious adverse incidents, there were cases that indeed ought properly to be investigated by the Coronial Inquisition. Now, it wouldn't be every case, one would imagine, that I would direct an inquest in, but at least relatives would have the reassurance of knowing that an independent set of eyes, mine and those of my colleagues, had looked at the circumstances involving their relative's death. I mentioned relative's death, of course. It's all very well if the deceased have people who will speak up for them in the context of a broader sort of supportive family, but I'm equally, possibly more worried about the people who have no one to speak up for them, that is, people dying elderly alone. And it would be the experience, not only of myself, but I suspect of very many people, that, to put it mildly, the quality of attention that patients get often is supported by the quality of representations that are made by a supportive and plainly engaged family circle.
And in terms of placing burden, say, on medical staff, would there be circumstances then perhaps something could be referred to the coroner's court that wouldn't be necessary?
I certainly wouldn't be referring any case to the coroner's court that wouldn't be necessary.
But what about the medical people themselves? Would be feeling that if they didn't do it, then the extra pair of eyes, so to speak, would be upon them?
No, well, in my view, it would be a very exceptional case which they class as a serious adverse incident, where the incident was in any way causative of death, which ought not to go to the coroner. But such cases, as we've plainly seen, do exist. This will close that gap. Then, of course, there's the category of case which is in the territory of Donald Rumsfeld, unknown unknowns, where cases may perhaps properly be classified, or we may think ought to be classified as serious adverse incidents, but are not at present.
Thank you.
Okay. Okay. No other questions?
Sorry, Chair. Can I-
Yes, Mr.
Just one quick point, Attorney General. I noticed the law centre states that it would not circumscribe this power to cover only deaths which occur in hospital, in recognition that the principles apply in other deaths which may fall within the Attorney General's ambit to direct an inquest. Are you confident that it would only relate to deaths in hospital?
Oh, deaths in hospitals or, for example, residential homes. So, for example, if there was an example of ill treatment in a residential home, that could certainly fall within the purview of this provision, and I'm very glad that it would.
But not outside the remit
No,
of
no, it's health, social care. So, for example, frankly, there are cases which I'm looking at relative to the past where it would be very handy to be able to call on the information, and I can't. I'm quite clear that this provision can't be used other than in a health and social care context. I mean, there are few enough absolutes in the law. That's one of them, I'm quite certain.
Okay. Sorry, Mr. McCorley.
Would you foresee that cases of suicide where someone was undergoing counselling, could there be cases where maybe the counsellor might be found to be at fault in being neglectful or something, or some way, in contributing to a suicide death?
Well, of course, that will be a matter for the coroner's inquest to look at those things. But in a set of circumstances, and one knows anecdotally that there is concern among GPs when they make referrals of patients who they consider are suffering, for example, from depression, about how some of those cases are dealt with. The kind of cases you refer to would certainly fall within this provision, and the necessary information could be sought about them.
Yeah, I'm thinking about, I mean, I actually heard about a case last week, and where a person had suicidal thoughts. It was a school child, and apparently the services of counsellor weren't going to be available for 2 weeks. So you're talking about burdens on the health and social care service, and I can see, I mean, I do hear unofficially from people who work in that environment that there are heavy burdens on the needs for counselling and people with suicidal thoughts. And I could see how there might be circumstances where, due to just those kind of heavy burdens, people might end up being seen as being neglectful and maybe in some way contributing.
Well, I think the reassurance which individual counsellors conscientiously carrying out often very difficult work have is that the coroner's inquest doesn't make findings itself of civil, far less criminal liability. So I think it's important to bear that in mind. I think the function of the coroner's inquest in the context of health and social care cases is obviously to bring understanding to the family, so they can understand how, in what circumstances their loved one met his or her death, but also for us more broadly as a community to learn lessons. And we're all aware in different contexts of the need to learn more about the awful affliction of suicide in many communities today.
Yeah, I think just this might flag up again the shortfalls in the system. Thank you.
Okay. No other members? All right, Attorney General. Thank you.
Chairman, thank you very much indeed.
Thank you. Yes. Okay, members, in terms of the issue of the scope of this bill, if we were minded to support the Attorney General's amendment, obviously we can do that, but we can seek some advice from the bill clerks, their office, just to get some guidance. If it ultimately it's a matter for the Speaker and the Assembly to decide if the Speaker, if it's within the scope. So we can get some advice from the bill clerk if this amendment would be admissible, and that can inform members for next week whenever we'll go through the clause by clause. Mr. Elliott.
Chair, thanks. I think that's useful. The other query was if it needs cross-cutting support in the executive, and I'm assuming we can, would that advice come through the Speaker's office as well, or is that not our remit at all?
The committee can put down an amendment, so it would be a committee amendment
Okay.
that the Attorney General is seeking to get this through, as opposed to a departmental amendment. So if the committee decide that we want to put forward the amendment on behalf of the Attorney General, there's no recourse. We don't need to go to the executive to get permission to do that. The committee can decide to do it. So it's very much a matter for this committee to determine. So we'll get advice for next week if it would be within the scope of the bill from the bill clerk's office, and then that'll inform members. Item 6 then is legal aid reform and proposals to change Crown Court remuneration arrangements for solicitors and counsel representing defendants. And officials are here today to talk to us about this, so if they want to come back again. Officials had attended the meeting in February this year to outline the key issues raised during a public consultation on proposed changes to legal aid for Crown Court proceedings, cost rules 2005 and the Department's preliminary views on the way forward. At that stage, officials indicated that they were continuing to engage with the Law Society and the Bar Council to narrow the issues of contention with a view to getting a measure of agreement to changes in the fee structure. And today we'll hear a briefing on this. So the Belfast Solicitors Association has been in correspondence with the committee, outlining its opposition to the proposals and asking the committee to question the assumptions on which they're based and then to reject them. That letter is on page 138 of your meeting folder. Chief Executive of the Bar Council has also written indicating the Council has not yet seen the final proposals as they relate to the Bar, but would welcome an opportunity to outline to the committee the views of the profession prior to any final decision being taken. And that letter is in your table pack. A letter has also been received from the Chief Executive of the Law Society requesting an opportunity to brief the committee on the proposals, and a copy of that letter has been tabled for members. So let me welcome again back Mark McGuigan, Deputy Director, John Halliday and Nigel Hamilton, all from the Legal Services Division within the Department of Justice. And as before, this will be recorded by Hansard and published in due course. So Mark, I'm going to invite you to give us an outline of where we're at.
Thank you, Chairman. Thank you for your introduction. The purpose of our visit to the committee today is to update you on our proposals to make statutory rules that will change the remuneration arrangements for solicitor and counsel representing defendants in the Crown Court. You've already mentioned that in February we provided an interim report following the public consultation on Crown Court fees. Following that briefing, we continued to engage bilaterally with the Law Society and the Bar Council. Our aim was to get a better understanding of their objections and to hear their views on options in respect of guilty pleas. We were keen to ascertain if there were any areas on which we could reach agreement. You're already familiar with some of the concerns that have been expressed. For example, there was a suggestion that our comparison with the graduated fee scheme operated in England and Wales was fundamentally flawed, and that the graduated fee scheme did not remunerate solicitors for attending counsel in the Crown Court. We are clear from the published guidelines that attendance at court was covered in the graduated fee scheme, and that, overall, the comparison was valid. However, it is the case that in England and Wales, solicitors no longer attend counsel as regularly as they did previously, and this differs from the current position in Northern Ireland. The Minister was mindful of the potential for unintended consequences if the level of fees resulted in a fundamental change without a full assessment of the possible implications. As a result, we have adjusted the reductions pending fuller consideration of this issue. In addition, as part of the process of engagement, a couple of errors were identified in our analysis, and the final proposals have been adjusted to reflect these. We've listened very carefully to the representations which were made to us about the current structure, where existing fees might be protected, where some offences might be reclassified to recognised seriousness, and where new fees might be required. Where possible, we have incorporated these into our proposals. The new rules which we propose to make will have the effect of reducing levels of remuneration for solicitors by 27%, and for counsel by 22%, bringing the level of remuneration in Northern Ireland more into line with England and Wales. The new rules would have the potential to provide savings in the region of £3.6 million to criminal legal aid. Following the introduction of these changes, the Department is satisfied that the cost of running similar cases in the Crown Court in Northern Ireland compared with England and Wales will be very similar, though solicitors and counsel in Northern Ireland would still be better remunerated than their counterparts. We are also satisfied that these savings can be made without any diminution in the quality of service provided to Crown Court defendants. I'd like to set out for the committee briefly the main changes which will be delivered in the new rules. The new rules would remove the existing Guilty Plea 1 and 2 fees for both solicitors and counsel, and this follows a recommendation by the Criminal Justice Inspectorate. Solicitors would get a single guilty plea fee with a 3-band structure providing enhanced fees determined by the number of pages of served evidence. These fees recognise that more remuneration would be provided for bigger cases. Counsel would get a single guilty plea fee which can be augmented by trial preparation fees in appropriate circumstances. Again, these fees recognise that more remuneration would be provided for bigger cases. The enhanced fees triggered by pages of served evidence would be rebalanced so that the fees paid for less serious cases of offence are no longer at the same rate as the more serious classes. The additional fees relating to pages of served evidence at paragraph 18b of the 2005 rules will be removed, but served evidence above certain limits will still receive an enhancement. Taking account of the savings flowing from these measures, the remainder of the scale fees were reduced in order to deliver the required savings, but with the following exceptions, which arose following representations made by the Law Society and the Bar Council. Trial refresher fees and fees in the table of additional fees should be preserved at existing rates for both solicitors and counsel. The fees in classes A and D should be preserved at existing rates for counsel. The classification of cases in respect of hijacking and driving offences causing death should be reclassified upwards to Class D. Specific fees should be provided for confiscation hearings, which would be at the level of the highest daily refresher rate. And we will amend the existing interpretation of the rules governing the payment for half-day and full-day refresher. These are the key changes to the fee structure, and the full details are in the written report. In addition, we consulted on a number of other proposals. We intend to proceed as follows. We will take the necessary action to introduce rules setting out the conditions to be met before a defendant can change his legal team in the middle of a trial. That's the assignment of solicitors and counsel rules. We will amend the rules to require claims to be received by the Department or the Commission within 3 months of the conclusion of proceedings, rather than being submitted within 3 months of the conclusion of proceedings. And we will amend the rules to require a formal review of these rules to be completed every 3 years rather than every 2 years. We will recategorise applications for extended and indeterminate sentences, sexual offences prevention orders and disqualification orders under the title of public protection applications. Whilst we see merit in establishing a public defender service, we do not propose to bring forward detailed proposals at this time. Similarly, we do not propose to proceed with the introduction of a system of contracts at this time, although this is something that we should return to in the relatively near future. We believe that the proposals which we have outlined to you today are proportionate changes to the remuneration in the Crown Court, and that they pass the value for money test. Finally, Chairman, when we last appeared before the committee, we were asked about how the costs in Northern Ireland compared with England and Wales. This is a complex issue, as the component parts of the systems are very different. We are trying to work up an analysis which would be of value to the committee, and I will present this in due course. However, I can advise that in respect of the types of cases which normally run in the Crown Court in Northern Ireland, when these changes are introduced, the level of remuneration, while not the same as in England and Wales, will be quite similar. I'm happy to take any questions.
Okay. Obviously, the discussions with Law Society and Bar Council didn't get a unified outcome that you're able to present to us today. Are you close?
I think that the Bar Council and the Law Society maintained their view that there were a number of perspectives, I guess. First of all, the reductions which were implemented in 2011 were quite severe, and in their view were sufficient to bring fees down within budget. Secondly, they believed that they hadn't worked their way fully through the system to have full effect. Thirdly, they questioned our analysis and our comparison with the graduated fee scheme from a number of perspectives. The Crown Court in England and Wales hear a much broader range of cases than happens in Northern Ireland. Some of the cases which would be heard in the Crown Court in England and Wales would be heard in the magistrates' courts here. However, we did present to them our analysis. We gave them access to the information which we had used. We had picked a random sample of the cases which run in Northern Ireland, and on reviewing that again, we're quite clear that that was a representative sample. So it's difficult when you're going to the two representatives of the profession in terms of saying we want to cut the fees which you're currently enjoying, and to get their agreement to do that. And I tried not to drop any clangers. But, we did listen very carefully to the representations which were made to us. And we have, in the case of both the Bar Council and the Law Society, adjusted where the reductions have fallen to protect those areas where they felt the main work was being done and to reflect properly the work for which the fees were intended.
Members, go ahead. Mr. McCartney.
I mean, something that has always been part of this is the comparison between England and Wales. The systems are somewhat different in terms of what type of cases. So how do you satisfy yourself you're making the right comparison?
Because what we did was we took a sample of cases which actually ran in Northern Ireland, 213 cases out of about 2,000 cases in that particular year. We looked at that and we subsequently reviewed it again after the representations from the Bar and the Law Society and concluded that it was representative of the cases which ran in that particular year. We looked at those individual cases and we applied fee structure which would have operated had those cases run in England and Wales. And we compared that against the fees which were actually paid in Northern Ireland. And that's where we came up with the differences at quite a detailed level against solicitors, against each of the levels of council, junior council, senior council, lead junior, and so on. So it was quite clear that if that case had been run in England and Wales and the graduated fee scheme which operates there had been applied, you could see the amount of the fee which would have been awarded in that case. And that represented the cases which run in Northern Ireland. So you're removing, if you like, any of the inconsistencies which are due to different types of cases being run in another jurisdiction, or the volumes of cases which are operating there as well.
Okay. And were they all criminal trials?
Yes, they're all criminal trials.
So, I mean, the Law Society would make the argument that if you strip this away, that the sort of, if you like, the cost per head for criminal trials would be similar to what it is in England and Wales. You make a different proposition?
Well,
you take it across the whole legal aid spectrum rather than, say, criminal, civil and family?
Well, we look at it from a number of different perspectives, and we can work out the average cost per case in criminal cases. The difficulty is when you then try to apply that in England and Wales, because they have a broader range of cases in the Crown Court, there are different factors at work there. So, and that's part of the problem. We're committed to providing the committee with a further analysis of this. Part of the problem is getting underneath the skin of what does that include. There are an enormous number of cases operating there, and they're across a wide spectrum. That's why we believe quite firmly that when you take the cases which actually run in the Crown Court in Northern Ireland and apply the fee scheme from England and Wales to those cases, you're getting a true reflection of the types of the cases and the fees which would be paid if the graduated fee scheme operated here.
And when you're doing your comparison, do you take a different economic circumstances, say like economic activities higher here than, let's say, in England? Or?
No, because we're looking just at the fees which are paid to the legal profession.
Yeah.
I mean, in terms of the amount of fee which a solicitor or a barrister would get in Northern Ireland as opposed to in
it's just
Wales.
that's the only impact you do. You don't do a broader, saying the people involved, their circumstances, no?
In terms of the defendants?
Yeah.
Well, there's nothing in these... there's nothing in these proposals which impact on the defendants in a case. There's nothing there which reduces the scope. It is still the same level of legal representation which will be available to a defendant as in the case of the criminal cases as awarded by the court. And all that we're doing is impacting on the actual cost associated with providing that.
And in terms of impact, just again, what's the percentage cut that you're proposing?
For solicitors, it is 27%, and for barristers, it is 22%. Our original proposals were for a cut of 46% in solicitors and a cut of 40% on average for barristers.
Sorry, could I correct that, Chairman? It was 30%
Well,
barristers.
after the GP2s.
Oh, yes, sorry.
Sorry.
Okay.
We have this debate all the time.
Yeah, no, that's okay.
What was the original figure for solicitors? 40?
46.
Okay. And in terms of assessing that impact, you know, like, in terms of employment, do you do any read of that, or is that just out beyond what you do?
Well, we would like to do more, but we don't have an enormous amount of data in terms of the earnings. We know how much legal aid is paid to individual firms, but we don't have any additional economic data around the other earnings that those firms might have and how this would impact. But I think in terms of where we are, and in comparison with England and Wales, clearly these fees are being paid in England and Wales, and people are continuing to be represented. We aren't cutting just quite as far as England and Wales have done before, and we're a step behind them as well in terms of their latest proposals.
And in terms of urban-rural, would you do any comparison there?
Again, we
In
don't.
terms of impact, just in terms of impact.
We don't have the information, again, because it's down to saying how much earnings does a solicitor's firm have through legal aid, and then what are the other earnings that solicitor's firm would have. I mean, I think that I wouldn't like to speculate, but I suspect that a lot of the legal aid falls within the Greater Belfast area.
Can we actually ask the Law Society and the Bar Council to provide us information on other earnings and profit margins? But none was forthcoming.
That was asked for?
It was asked for.
Okay. Okay, thank you.
Okay. Mr. Lynch?
Thank you, Chair. Mark, you said that you had made some adjustments in some important fields of the work. What were they?
I think I identified a couple of them as I went through. A couple of examples. In terms of council, we've protected the Class A fees, which are the murder and series, and Class D, which are the more serious classes of offence. We've protected the trial refresher fees. So, if you're a counsel, for example, you'll get a standard fee, and then when the case goes to trial, after the first day of trial, you'll get a refresher fee. We've protected the levels of those fees. It's fair to say that those fees, the level of refresher that we pay, is lower than is paid in the graduated fee scheme in England and Wales, but then our basic fee is sitting at a higher level. And there are some additional fees which are awarded, some of which are below £100, for example, so we've protected those as well. And those were in response to the representations which were made to us to say, if you have to make cuts, to try and protect these areas.
And secondly, Chair, you said you would work up an analysis and give us an update. What will that comprise of?
What we're trying to do with that is to look at the impact of the cost reduction in Northern Ireland already since 2011, but that's complicated by the increase in business through the Crown Court. We can demonstrate quite clearly, and it's a question which Mr Elliott asked before, that the VHCC has virtually worked its way out of the Crown Court now. There are a number of bills still outstanding, and they'll be cleared, hopefully in this financial year, but I understand all of those cases are if they're not finished, they're very close to finishing. You can see also in some of the more serious cases where now that the VHCCs are in the more serious categories and remunerated through the normal fee system, there's a slight increase in that. But you can see a downward trajectory overall from 2011 in the average cost. What we're trying to do then is to get some sense of the figures in England and Wales, which are comparable to ours, so that you're actually comparing like for like and not taking, because if you just took the overall figures of legal aid and divided it by what they call the number of acts of assistance, you actually get quite a low figure. We think that that's obscuring some facts, and therefore we want to be able to give information to the committee which is comparing the situation in Northern Ireland on a like-for-like basis with England and Wales. But it is, and I apologise for this, it is complex in terms of trying to make sense of it.
Okay, Chair, thank you.
Mr McCartney's a wee follow-up, and then I'll bring in Mr Foley.
It's just where the process is with the two professions. Have you concluded now, or any more discussions?
We've finished this round of discussions, and I noted in the comment from the correspondence at the start of the session that they pointed out they hadn't seen the final proposals. Our normal practice is that we share that with the committee in the first instance, and on our return to the office today, we will send both the professions, or both branches of the profession, the final document, the report. We will continue we're engaging with them on other areas and in other matters, and civil legal aid and the registration scheme, for example, is something which will be continuing. We'll also, there are a number of things which came out of this discussion about reclassification of offences and are offences classified in the right way. Those are discussions that we'd want to continue to have with them as well, going on. So we will be having a continuing engagement with them, and no doubt they'll want to talk about these as well.
Okay, Ms McCorley.
Do you think enough consideration has been given to the way that different models operating in Wales compared to here in the north, so that you have smaller firms here with less flexibility and different ways of operating, so that they will be impacted more severely due to these cuts than can be spread out over bigger practices in England and Wales, and a result of that would be that people in need of justice and access to justice will not get the access to justice that they are entitled to, so that justice might not be served.
I don't think that this will impact on the ability of any defendant to be able to access the appropriate legal representation if they're a defendant in a Crown Court case. I cannot say that it won't have an impact on some business models as currently operate. But what we're trying to achieve here is to get the value for money, is to maintain the level of access to justice, but also to do that at an economic rate and to obtain value for money for the money that the executive is putting into the legal aid fund. I can't honestly say what the impact would be on any individual business, because we don't have that, and as John has said, we've asked the Law Society, in particular in the Bar Council, for information in relation to those profit costs and the margins and the other things which they're doing outside of legal aid. But they haven't been able to share that with us if they have it. And it may well be that some organisations may well need to look at their current businesses' practices and adjust those. But having said that, we're looking at what is an economic rate in terms of the work that needs to be done.
Yeah, but we are hearing from people involved in legal practices that it will result in people not being able to survive because the fees and remuneration will not be sufficient for the caseload. So they either have to reduce the service and give a poorer service, or else go and do something else. And there are fears that might happen, and the impacts of that will be felt later. That's the difficulty.
In terms of our analysis, we think that this is an economic rate. It's currently it's above what's currently paid in England and Wales in relation to those particular classes of cases, and people are able to make to manage their firms as a result of that. There are other impacts. There are other factors which will have an impact on the wider economic environment, will have an impact on some organisations, I don't doubt. But I think that in terms of the inputs which are required here, and particularly in relation to the Crown Courts, we think that is an economic rate which also passes the value for money test.
Thanks.
John, yourself.
Chair, thanks. Thanks again for. There's just a couple of issues. The guilty plea 1 and 2 being removed, and I still don't fully understand that coming from the legal perspective. But do you believe it'll put any further pressure on defendants to have an early guilty plea whereby they may be innocent because of the changes that's being proposed here?
I don't believe that at all.
What makes you so confident of that, Mark?
Well, you're suggesting that if somebody is innocent of a crime because of the fees which are being paid to the lawyer, they would feel pressurised to plead guilty.
Yeah.
I can't see that the fee structure would encourage them to do that. And indeed, what we're doing is addressing some of the inconsistencies in the existing guilty plea fees, where, for example, at the guilty plea 2 level, you currently get a much higher fee and a higher fee than you would get if you go to trial. There are still some overlaps, but what we have done in respect of the fees going forward is that in classes of trials and in the size, or sorry, in classes of cases and in the size of a particular case, you'll no longer benefit from a higher award for a guilty plea than you would have earned if you go to trial. So that's the solicitor or the barrister. In the past, that wasn't quite the case. So if anything, we've pushed it the other way in terms if there's an individual who is innocent, then they should take the case to its conclusion.
Okay. My other point is around the overall review process of the justice system and where savings can be made. And I have always said I fully support savings being made wherever they can be, and if that's in the legal aid system, then it must be done. But I'm always reluctant to do it in the context of doing it in a piecemeal approach, instead of having an overall review whereby it identifies where there needs to be further efficiencies, whether that's in the court service, in the public prosecution service, in the legal aid system. I just feel there should be an overall review, and it needs to be done in a holistic context so that we get the best efficiencies everywhere instead of picking off small bits and doing it in piecemeal.
I think each organisation is looking at its own arrangements in terms of how efficient it is and what steps can be taken to drive further efficiency out of the system. And I think David Ford will be bringing forward the Access to Justice Review Part 2, which will in part look at some of those and look and see whether there are further efficiencies. But if you do it on a holistic basis, it would be a huge undertaking, which would take some time to do. I think it's also fair to say that there are a number of other things going on. For example, with DHSS, we're working on the pilot for the family system to see how that can be improved. So there are a number of different things going on around the system which overall would provide improvements.
I do accept, Mark, that it would be a huge undertaking to do an overall review, accept that. But the argument and the allegation that will come back is the legal aid reduction is easy picking, whereby it may not be where there is the most efficiencies to be got. And I don't know, I'm only saying what the allegation is and the perception that may come back. Yeah. But clearly, I feel that there are other areas within the justice system where there can be more efficiencies. I'm absolutely convinced of that. Yeah. And they're getting away without having the cuts or reductions that some other parts would have.
I think there are some proposals being brought forward in the Faster Fairer Justice Bill which will do some of that. It's not a big review. I think in terms of and focusing back in on where we are today in the Crown Court fees, I think what we've done here is looked at the value for money argument and comparisons with other jurisdictions. So notwithstanding if you can do things more efficiently, the level of fees which are currently being awarded in Northern Ireland are higher than in England and Wales for those similar types of cases. I also think it's back a little bit as well to the discussion we were having earlier this afternoon on the Legal Aid and Coroners Courts Bill, where with the creation of the agency, we will be looking to modernise the systems and processes that currently govern legal aid, so we can streamline and make it more efficient for solicitors in private practice to engage and so on, so online applications and that sort of thing. So there are a range of other things which will go forward as well.
Okay, and have you made comparisons? There is quite a comparison in this aspect with England and Wales. Has there been comparisons made with other aspects within the justice system to England and Wales as well? For example, the Public Prosecution Service. And that's only one example.
It's not my remit. I couldn't honestly answer that question.
We work closely with the Public Prosecution Service because they tend to adopt a lot of our fees, and so we benchmark with them to see what they thought of our fees.
Sorry, I misunderstood the question. Are you asking us, did we talk to the Public Prosecution Service and see are our fees aligned with theirs?
I'm asking if other areas within the justice system have been compared for cost efficiencies and cost effectiveness with their counterparts in England and Wales. For example, and only used the Public Prosecution Service as an example. Well, I could have used the court service.
I thought that's what you were asking, but John does make a very valid point, and I'll come back to that in just a second. I'm not aware of other comparisons which are going on, but I have no doubt that they do. We all strive to improve our efficiency, and we all strive to see the closest model that we can look at and benchmark ourselves against that. So I have no doubt that those sorts of things are being done. How formally or structured they are, I'm not aware of that. But in relation to, and maybe it gives some confidence as well, in relation to the Crown Court fees, we did talk to the colleagues in Public Prosecution Service and discussed with them our proposals for changes to ensure that we didn't do any mishap to their fees, and to align as far as possible the fees which we are paying, recognising the two different functions that are carried out there. And of course, it's the Public Prosecution Service will have in-house lawyers at solicitor level, but will employ barristers. So, we did some benchmarking and discussions with them in terms of the proposals that we've brought forward here.
Yes, it's a new part to my question, Chair, but it would be useful to have that comparison, actually, of the costs of the legal aid system for defendants and the costs within the Public Prosecution Service for the prosecution.
What they do, Chairman, is they actually take our fees, but they make certain differences, because generally you will get one prosecutor who might be prosecuting 5 defendants, whereas each defendant will have his own team. So they then increase the fee a wee bit, because he's having to take the 5 cases. So generally they will take our fees with a few differences.
But still would be a useful comparison for us to have, just to see how much it is costing to prosecute compared to how much it is costing to defend.
Well, we'll talk to the Public Prosecution Service about that.
Sorry?
We'll talk to the Public Prosecution Service about that. And I mean, I'm sure that their fees are published.
Yeah, it's a difficult comparison, because the PPS have the benefit of the police putting the case together for them and marshalling witnesses, whereas for the defence it's up to the solicitor and counsel to actually marshal the defence.
Accept that.
It's a different role and a different that they undertake.
Okay.
Thank you, Chair.
Okay. There's no other questions from members, so thank you very much.
Thank you.
Thank you very much. Okay, members. I, along with the Deputy Chairman, have met with the Chief Inspector, Brendan McGuigan, of the CG Criminal Justice Inspection last week in respect of the range of legal aid reforms the Department is bringing forward. He indicated that CGI could undertake some work, including on the civil legal aid side, and that will require the agreement of the Minister. The Chief Inspector also intends to write to the committee regarding in terms of reference, timescales and a staged approach to the work, and has suggested that the first phase could consider the impact of Crown Court fees that have already been introduced, any issues that have arisen, the effects of the position adopted in England, Wales, and the potential consequences of this approach in Northern Ireland, taking account of our particular circumstances. An initial snapshot, including the views of stakeholders, could be provided for the end of June. So obviously the Department is coming to the conclusion point in bringing forward their final proposals to this committee, which we'll ultimately need to agree with or not. So I think it would be useful if we can get some initial soundings out of the CGI. If members are content, we'll invite the Bar Council and the Law Society to come up to the committee to talk to them about it. But obviously, if there isn't a final meeting of minds between the professions and the Department, we'll be left to have to take the final call on it with the proposals that are put in front of us. So if members are content, we'll get the two legal bodies here, and we will hopefully have a CGI report as well to help inform us when we have to take those decisions.
But there was no indication there today from the Department that there was a meeting of minds. They just said they seem to have concluded their talks on this issue.
Yeah, that was my sense of it. Okay, item 7, Mental Capacity Bill consultation document. Page 201 to 442, your meeting folder. The Department's provided the committee with a copy of the draft consultation document on the Mental Capacity Bill. The consultation was launched yesterday in conjunction with the Department of Health, Social Service, Public Safety. It closes on the 2nd of September. The Department of Justice has confirmed that the intention is to introduce the bill as early as possible in January 2015. Members will recall that there will be a joint ad hoc committee composed of members of this committee and the Health Committee to be formed that will scrutinise the results of this consultation exercise and then the bill itself. So members are asked to note the launch of the public consultation on the proposed mental capacity legislation, and if we can also agree, we'll write to the Department asking when it aims to have the analysis of this response completed and to be in a position to brief the joint ad hoc committee. Okay. Item 8, the Attorney General. On the 13th of February this year, the committee agreed that we were content with the draft guidance from the AG in respect of the PPS on the exercise of its functions in a manner consistent with international human rights standards. The committee subsequently agreed on the 30th of April that it was content with the proposed stat rule that would bring the guidance into operation on the 9th of June. The statutory rule was laid by the Attorney General on the 14th of May. It's subject to negative resolution procedure. There's been no changes to the policy content since the SL1 was submitted. To the committee, the Assembly Examiner of Statutory Rules has confirmed that he has no issues to raise with regard to the technical aspects of the rule. So on that basis, if members are content with the statutory rule, I'll formally put the question that the Committee for Justice considered Statutory Rule 2014 number 131, the Attorney General's Human Rights Guidance, Public Prosecution Service for Northern Ireland Order, Northern Ireland 2014, and has no objection to the rule. Agreed?
Agreed.
Similarly, on the 13th of February, we agreed that we were content with the draft guidance from the Attorney General in respect of the Northern Ireland Prison Service on the exercise of its functions consistent with international human rights standards. We agreed on the 30th of April that we were content with the stat rule. The stat rule has been laid. It's subject to negative resolution procedure. There's been no change in policy terms from its laying, and the Examiner of Statutory Rules has no issues with it. So if members are content, I formally put the question that the Committee for Justice considered Statutory Rule 2014 number 132, the Attorney General's Human Rights Guidance, Northern Ireland Prison Service, Conditions of Imprisonment, Order, Northern Ireland 2014, and has no objection to the rule. Agreed? Agreed? Yes. Item 10, Police and Criminal Evidence. Page 502. At our meeting on the 7th of May, the committee considered and agreed that it was content with the proposal from the Department to make a statutory rule to bring into operation changes to PACE Code C, detention, treatment and questioning of persons by police officers, and Code H, detention, treatment and questioning of detained terrorist suspects, to ensure Northern Ireland is compliant with the EU directive on the right to information in criminal proceedings. The statutory rule was laid by the Department on the 12th of May. Subject to negative resolution procedure, the Stat Rule will bring the revised PACE codes into operation on the 2nd of June. There have been no changes to the policy content since it was submitted to the committee, and the Examiner's Statutory Rules has no issues in regards to any technical aspects. So if members are content, I'll put this formal question that the Committee for Justice considered Statutory Rule 2014 number 134, the Police and Criminal Evidence 1989 Order, Codes of Practice, Revision of Code C and H, Order Northern Ireland 2014, and has no objection to the rule. Agreed? Draft Stat Rules on Sexual Offences Act notification requirements at a meeting on the 6th of December back in 2012. The committee considered a proposal by the Department of Justice to make a Stat Rule to amend the Sexual Offences Act 2003 and introduce new information requirements which sex offenders subject to notification under Part 2 of the 2003 Act must provide to police. Just to advise members, the draft rule is subject to the affirmative resolution procedure. It's been laid by the Department of Justice and officials, and indicated that the Minister plans to have the rule debated in plenary on Monday the 23rd of June. There have been no changes to the policy content since the SL1 was submitted to the committee, and the Assembly Examiner for Statutory Rules has confirmed there are no technical issues to the rule. If we're content with the statutory rule, then I'll formally put the question that the Committee for Justice consider draft statutory rule, the Sexual Offences Act 2003 notification requirements regulations Northern Ireland 2014, and recommends that it be affirmed by the Assembly. Agreed? Item 12, page 641 to 655, at a meeting on the 13th to 3rd of April, the Committee agreed that we were content with draft guidance from the Attorney-General for Northern Ireland for the Northern Ireland Prison Service on the exercise of its functions in relation to prison order and discipline in a manner consistent with international human rights standards. The draft guidance was subsequently laid in the Assembly on the 10th of April this year. The Committee noted it at the meeting on the 7th of May. The Attorney-General has now provided information on the proposed statutory rule, which will bring the guidance into operation on the 7th of July. The statutory rule will be subject to the negative resolution procedure. If members are content with the proposed stat rule, or if of any further information is required. Members content, and then we'll get the formal question in due course. Item 13, page 657, the Public Service Pensions Act. Northern Ireland 2014 will replace final salary pensions with career average revalued earnings pensions for public service after the 31st of March 2015. The Department, as the responsible authority for the devolved judiciary, must establish a care pension for those office holders by the 1st of April 2015. The Department needs to make the scheme regulations, which will set out the mechanics of the care scheme and an order specifying which judicial office holders are eligible to join it. The scheme regulations are subject to draft affirmative Assembly procedure, whilst the order is subject to negative resolution procedure. Scheme regulations also require consent of the Department of Finance and Personnel. The scheme regulations will be very closely modelled on those to be made by the Department of Finance Personnel for civil servants and by the Ministry of Justice for the non-devolved judiciary. The Department intends to conduct a targeted consultation on the regulations with the devolved judiciary over the summer, and subordinate legislation proposals will then be presented to the committee for our consideration. So members are asked to note the Department's intended approach for a targeted consultation with the devolved judiciary on subordinate legislation to establish a care pension scheme. Unless members need any more information, we will note it. Item 14. In January of this year, the Minister of Justice launched a 12-week consultation on proposals to strengthen Northern Ireland's fight against human trafficking and slavery. Proposals which were in part informed by the measures in the Home Secretary's Modern Slavery Bill seek to simplify the legislative framework to make it easier for investigators and prosecutors to bring cases against perpetrators, protect the public through changes to the sentencing framework and the introduction of new civil orders, provide effective oversight and expertise, and enhance understanding of these offences and how they occur in Northern Ireland, so that the Department can develop better strategies and policies to protect against them. 40 responses were received to the consultation, and the departmental briefing paper provides an overview of the responses, including any issues raised and where support or opposition has been expressed, and outlines how the Minister of Justice intends to proceed. Having considered the consultation responses, the Minister intends to bring forward legislative changes as part of Lord Morrow's Human Trafficking and Exploitation Bill in relation to the consolidation of offences, sentencing, civil orders and improving data collection and assessment. Lord Morrow has indicated that he is supportive in principle of this approach and has agreed to defer consideration stage of his bill until late September or October to allow the Department to prepare the draft clauses. So just to advise members, depending on the views of this committee, the Department will prepare draft clauses for the consideration of the committee and executive approval in September. So members are asked to note the results of the Department's consultation on strengthening Northern Ireland's response to human trafficking and slavery. And members are content with the Department's proposed legislative changes, unless there's any more information members wish to have. Otherwise, we'll note it and indicate our contentment. Item 15, the Reducing Offending and Partnership Initiative, which comprises the Department of Justice, PSNI, Probation Board, Youth Justice Agency and the Prison Service, was officially launched in May 2013 across Northern Ireland by the Minister, with the aim of reducing crime and dealing with the most prolific offenders. The Department has provided a progress report on the initiative, which sets out the 3 distinct strands relating to prevent and deter, catch and control, rehabilitate and resettlement, highlights the benefits as a result of the introduction of the initiative and the areas of work to be undertaken to be taken forward to develop it further. So members are asked to note the progress report on this particular initiative. Unless members want any more information, we will duly note it. Noted. Item 16. In light of reforms to police officers' terms and conditions in Great Britain and in consideration of financial pressures on the policing budget, the Minister of Justice asked the Police Negotiation Board to review the terms and conditions of police officers serving in the PSNI, to consider management practices, the maintenance of interoperability and the support to the PSNI and more effective use of finances. The Department has now provided a briefing paper outlining a range of reforms to PSNI officers' terms and conditions that will reduce police pay and allowance expenditure by approximately £16 million over the next 5 years, which have been agreed by a working group of the Police Negotiation Board and representatives of serving police officers, and endorsed by the full Police Negotiating Board and the Minister of Finance and Personnel. The next stage is for the Department of Justice to amend determinations and regulations where appropriate to ensure the revised terms and conditions are introduced by the dates agreed. The amendments will be made by subordinate legislation, which will come before the committee for consideration. So members are asked to note the agreement that has been reached on reforms of PSNI police officer terms and conditions. Unless members have any more queries, we will then duly note it. Noted correspondence. There's 8 items in the meeting folder and 2 items in the table pack. Item 2 in the meeting folder is correspondence from the Department providing further information requested by the Committee on the Criminal Justice Inspection Northern Ireland Report, securing attendance at court, a follow-up review of inspection recommendations. Members are asked to note the information which highlights new arrangements to collate and analyse adjournment reasons to address the lack of reliable data to explain why so many cracked and ineffective trials are occurring. Unless any further information is required by members, we will note that information, which I think is helpful. Item 7 is correspondence from the Northern Ireland Federation of Shooting and Sports in relation to the minimum age for holding a shotgun and the Minister's proposal to amend the legislation. If members note the views of the Federation, we can inform them that the Department is due to present its final proposed changes to firearms legislation to the Committee for consideration at our meeting on the 18th of June. Item 8 of correspondence is from the Police Federation for Northern Ireland, providing a copy of its submission to the Northern Ireland Affairs Select Committee in relation to its inquiry into the administrative scheme for the on-the-runs, and indicating that it would be willing to give oral evidence to the committee on the matter. So if members are content at this stage, we'll note the submission that's been made. Obviously, the Northern Ireland Select Affairs Committee is going through this process, and then we can have a look at this in due course. Item 1 is correspondence from FAST, Families Against Supergrass Trials, requesting an urgent meeting with the committee on the issue of supergrass trials. If members are content, as we have with some other meetings, we can have an informal meeting at some point, and we can factor that in. Item
Chair,
2.
there was correspondence from that organisation passed on to the department for a response, I think, at our last committee, so it would be useful to wait for that.
Then also there's an invite from NIACRO to an event called Never Ending Sentences, and it's on Friday at Queen's University, so if members want to attend that, you're welcome to do so. Is there any comments on the correspondence that I've left out?
Chair, there was one, I think it's 17.5, is it? The Department of Justice response on the their drug policy, or how they manage and try to stop drugs being brought into prison. It's actually quite a detailed summary or response. I'm just wondering how effective all their measures are. That's all. It might be useful, no need at this stage, I don't think, but it might be useful at some time in the future that we get a presentation around that whole aspect, because it is a huge issue within the prisons in Northern Ireland.
Okay.
So I would ask maybe that we consider for future planning that we ask the Prison Service to give us maybe an oral briefing on it, just for more detail.
Okay. Well, we can try and plan that in the work programme. Okay, we'll agree to action at the correspondence as outlined then in the meeting. Agreed. Chairman's business, there's a meeting and lunch with the Oireachtas Joint Committee of Justice, Defence and Equality. They'll be visiting Belfast on Wednesday the 11th of June. In connection with a review, it is undertaken into the effectiveness of the provisions of the Garda Síochána Act 2005, and in particular the powers and remit of the Garda Síochána Ombudsman Commission. Arrangements have been made for the Justice Committee to meet informally with members of the Joint Committee, and that'll be at approximately 12:15 p.m. to discuss the role and interaction of the Policing Board with the Committee and the Assembly. And then there'll be lunch with the members of that committee in the dining room. Finally then, item 2 is the member survey that has been circulated, and we would encourage members to fill that out. Is there any other business? If there's no other, then we'll meet next Wednesday at 2 o'clock in the same room.
The Northern Ireland Assembly Committee Room 21. This is the Northern